Welcome to Literary and Jury Charge Practice. Let's start out with this jury charge. Ready? Here we go. To assist you in your tasks as jurors, I will now explain how the trial will proceed. I will begin by identifying the parties to the case. David Kopage filed this lawsuit. He is called a plaintiff. He seeks damages from the California Institute of Technology, also known as Caltech, who is called a defendant. Kopage worked at the Jet Propulsion Laboratory, sometimes referred to as JPL, a NASA center managed by Caltech. First, each side may make an opening statement, but neither side is required to do so. An opening statement is not evidence. It is simply an outline to help you understand what that party expects the evidence will show. Also, because it is often difficult to give you the evidence in the order we would prefer, the opening statement allows you to keep an overview of the case in mind during the presentation of the evidence. Next, the jury will hear the evidence. Plaintiff will present evidence first. When plaintiff is finished, defendant will have an opportunity to present evidence. Each witness will first be questioned by the side that asked the witness to testify. That is called direct examination. Then the other side is permitted to question the witness. This is called cross-examination. Documents or objects referred to during the trial are called exhibits. Exhibits are given a number so that they may be clearly identified. Exhibits are not evidence until I admit them into evidence. During your deliberations, you will be able to look at all exhibits admitted into evidence. There are many rules that govern whether something will be admitted into evidence. As one side presents evidence, the other side has the right to object and to ask me to decide if the evidence is permitted by the rules. Usually, I will decide immediately, but sometimes I may have to hear arguments outside of your presence. After the evidence has been presented, I will instruct you on the law that applies to the case, and the attorneys will make closing arguments. What the parties say in closing argument is not evidence. The arguments are offered to help you understand the evidence and how the law applies to it. A nonprofit educational institution, the California Institute of Technology, or Caltech, is a party in this lawsuit. Kopage worked at the Jet Propulsion Laboratory, sometimes referred to as JPL, a NASA center managed by Caltech. JPL is entitled to the same fair and impartial treatment that you would give to an individual. You must decide this case with the same fairness that you would use if you were deciding the case between individuals. When I use words like person or he or she in these instructions to refer to a party, those instructions also apply to JPL. Plaintiff seeks non-economic damages for emotional distress. To recover damages for emotional distress, plaintiff must prove by a preponderance of the evidence that he suffered emotional distress as a result of his layoff or other actions by defendant that, taken as a whole, materially and adversely affected the terms and conditions of his employment. He also must prove the extent to which he suffered any such emotional distress. No fixed standard exists for deciding the amount of emotional distress damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. Plaintiff seeks damages from defendant under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether defendant is liable to plaintiff under the following legal theories: 1. Discrimination based on plaintiff's religious creed or perceived religious creed. 2, failure to prevent discrimination, and 3, retaliation in violation of the Fair Employment and Housing Act, and 4, retaliation, wrongful demotion, and wrongful termination in violation of public policy. The following items of damages are recoverable only once under all of the above legal theories: 1, wages and benefits, and 2, emotional distress. To satisfy his burden of proof on his claims for religious employment discrimination, retaliation, or wrongful demotion or termination, plaintiff must do so with admissible evidence, not assumption, conclusions, or speculation. Plaintiff claims that defendant wrongfully discriminated against him. To establish this claim, plaintiff must prove all of the following: 1, that defendant was an employer; 2, that plaintiff was an employee of defendant; 3, that defendant laid off plaintiff or took other actions that, taken as a whole, materially and adversely affected the terms and conditions of his employment; 4, that defendant perceived plaintiff's beliefs as religious; 5, that defendant's perception of plaintiff's beliefs as religious was a motivating reason for his layoff or other actions that, taken as a whole, materially and adversely affected the terms and conditions of his employment; 6, that plaintiff was harmed; and 7, that the layoff or other actions that, taken as a whole, materially and adversely affected the terms and conditions of his employment were a substantial factor in causing plaintiff's harm. If you find that defendant's actions, which are the subject of plaintiff's claim, were actually motivated by both discriminatory and non-discriminatory reasons, defendant is not liable if it can establish by a preponderance of the evidence that its legitimate reason standing alone would have induced it to make the same decision. Stop there for now, and let's see what we have for. We have a closing argument. Let's finish the closing argument up, and then we'll try some literary practice. Ready? Here we go. And conversely, it should say that Mr. Irvin was not negligent. Why? Because, like you heard the judge instruct you right at the end, the burden's changed. The person that's asserting a claim or defense has the burden of establishing it with by the preponderance of the evidence. In terms of his claim of negligence against Baltimore Tank Lines or Ms. Young, Mr. Irvin has the burden to show that that's more likely than not if the accident happened the way he says it did. If any of the defendants want to argue that Mr. Irvin was contributory negligent, that burden shifts to them. They have to show you by preponderance of the evidence that he was contributory negligent. And I submit to you that they can't do that because nobody saw what happened except for Mr. Irvin. And in the absence of any direct evidence that he was negligent, you should find that he wasn't. So I'm going to ask you to render a verdict that Baltimore Tank Lines was negligent and that their negligence was a cause of the accident. And I'm going to ask you to render a verdict that Mr. Irvin was not negligent. And I'm going to let you decide whether Cindy Young was negligent because it's a close call. You'll have to, looking at the circumstances, decide whether there was enough time for Ms. Young to decide to do something else. If there was time for her to do something else, then maybe she was negligent. If there wasn't time, then maybe she's not, but you'll have to make the decision. But what the evidence does show is that Baltimore Tank Lines, vehicle caused this accident, and there's nothing that contradicts it. Thank you, ladies and gentlemen. All right. That's the end of that. And let's try some literary practice. And we will carry on with an article that we had started previously about tips for going green. Ready? Here we go. Reusable food and drink containers. Members shared several different products that they use as refillable water bottles or drink containers, including the Swell water bottle, the Contigo water bottle, the Hydro flask, and Bubba travel mugs. I have a water bottle that I partially fill with lemon juice and water the night before and stick it in the freezer, said Catherine Wilson, a freelancer in Fieldcrest, Washington. Then the next day I add water to the top, so I have cold water for a while depending on the weather. One of the advantages to reusable water bottles is that they often help make it easier to stay hydrated during the workday, either because of convenience or design. My reusable glass water bottle means I am more likely to drink enough water in a day, as without it sitting on my desk. I forget to find time to drink, says Jody Stanton, a student in Spotswood, Victoria, Australia. If our bodies are hydrated properly, then we are able to think more clearly, said Bonnie Comstock, an instructor in Sacramento, California. Comstock has made a point of drinking 84 ounces of water a day. When I initially started drinking that much water, I was going to the restroom quite frequently. Now my body is used to it and I don't go as often. Being on the record presents unique challenges to staying hydrated. I've tried to rush a sip from a mug of liquid into my mouth and usually end up with it all over me when others start talking, said Dawn Redwine, RPR CRI, a freelancer in Albuquerque, New Mexico. Her solution was to find a reusable travel mug with a straw. Janine Farron, RPR CRR, agreed that a straw is a good feature on a reusable bottle. When I do pick it up to drink, I don't have to tip it to drink because it has a straw. I just reach over, pick it up, sip, and put it back down, said Farron, a freelancer in Fishers, Indiana. Mary Bader, RPR, an official in Eau Claire, Wisconsin, found a way to show her court reporter pride while being green. She brings her Wisconsin Court Reporters Association cup. Members also shared a variety of types of lunchboxes. Insulation and having multiple compartments are popular features. I have a cloth lunch bag with plastic lining that I got at Goodwill. It's fairly large and fits all my food for the day, said Wilson. Sarah Czar, an official in Lamar, Colorado, uses a bento box, which is a stackable lunch box. Basically, she explained, I have two nice lunch boxes. I switch out and pack a sandwich wrapped in wax paper, which I use for a placemat, said Susan Baker, RDR, a freelancer in Houston, Texas. Adina Raisin, a freelancer in New York. New York has a handy little sandwich-sized container, and every morning I make a PB&J that I throw in my bag, along with my steno machine, laptop, etc., as well as being a benefit to the environment to use reusable food containers. It also means that I eat much healthier by having a better choice of snack ready to go, said Stanton. It really doesn't take much extra effort at all, as I just add another container to the lineup while preparing kids' lunch boxes for school. Mornings can admittedly get hectic, so some members do the prep work beforehand. I fill bottles for everyone at the beginning of the week so we can grab and go during the week. In packing lunches, I use as many washable, reusable containers as possible. Besides being green, it keeps your sandwiches, chips, and fruit from being smashed in your lunchbox, says Ashley Dickey, RPR and official in Birmingham, Alabama. Prepping water bottles for the week takes just a few minutes of my day on Sunday. I also spend a few minutes getting fruit, chips, etc. into individual containers on Sunday. I have about a dozen reusable water bottles, assortment of plastic and glass, that I keep filled with water from my reverse osmosis system. I keep them in the garage refrigerator, so as my family leaves the house, they can grab fresh water on the go, said Linda Kentrell, RMR CRR, and official in Kingman, Arizona. Going green can be a big process, but there are many little steps to make it easier along the way, and there are benefits to doing so in all areas. Assessing information from anywhere when it's stored in the cloud, reading a good book during a commute on public transit, saving money on lower utility bills, and eating healthier. But perhaps the real benefit to going green is more selfless. I've found that having this routine saves me time in the long run, and it hopefully means a little less trash at the city dump, said Dawn Redwine about e-cycling. Right, let's see. Let's try some of this closing argument. This is a new one. Ready? Here we go. May it please the court, counsel. In just a moment, the court is going to give you your instructions, and they are going to talk to you about the elements of the crime in this case. They are going to give you two elements. The first element, that the defendant knowingly attempted to use a weapon of mass destruction. The second element, that the defendant knowingly attempted to use a weapon of mass destruction and knowingly did so against a person or property within the United States, and that the mail or any facility of interstate commerce was used in furtherance of the offense or the result of the offense, if it had succeeded, would have affected interstate commerce. We believe the court will go on to instruct you as to what an attempt is. We believe the court is going to instruct you that to find that the defendant attempted to use a weapon of mass destruction, you must find beyond a reasonable doubt that the defendant both intended to commit the offense and did an act constituting a substantial step towards the commission of that crime, which strongly corroborates the defendant's criminal intent and amounts to more than mere preparation. Before we talk in depth about attempt or substantial steps, let's talk about a few things that this case is not about. This case is not about whether Mr. Alda was a failure in his relationships or a failure academically. From the evidence, you can see that he was not a failure academically. From the evidence, you can see out of 130,000 people that graduated from high school the year Mr. Alda did, 5,000 were eligible for the SABIC scholarship. And of those 5,000 students, only 100 got a SABIC scholarship. Mr. Alda was one of those. If anything, he was academically gifted. But at the time frame of these events, strong and resounding jihadist operations were on his mind. He was focused on one thing and one thing only, and that was detonating a weapon of mass destruction in the United States. And so academics at that point became completely unimportant to him. Similarly, relationships. He may have talked over the web with other persons who encouraged him, who motivated him, who strengthened his desire for jihad. But beyond that, Mr. Alda had no need for relationships. All right, we will get back to this one another time. That will conclude our literary and jury charge practice.